Hello and welcome back to Business Law Online. This week we're going to be covering contracts. Obviously a really important subject for businesses. Contract law is really the foundation of private law, and it's important to understand the concepts herein. It can give you an advantage. Um, let's start first with a definition. What is a contract? A contract is, number one, a voluntary agreement, meaning that no one was forced to enter into this agreement. No one had a gun to their head. It's a voluntary agreement entered into by two or more competent parties. What does that mean? That the parties understood the legal implications of what it is they were doing. For the most part, that's most adults. People excluded from this category include incompetents, that is, people who have been adjudged unable to take care of their own affairs, and two, minors. For the most part, there are actually some exceptions where minors can enter into contracts, but for the most part, they're not permitted to enter into contracts. Now, it's a voluntary agreement by two or more competent parties, and it's supported by what? It's supported by mutual valid consideration to do or not do something. What does that mean? That means each party is giving something up. It's not a gift. Each party is giving up something of legal value. Usually it's a set of promises. One party promises to do something, the other party in return promises to do something else. But it doesn't necessarily have to be that way. We'll go over the different types of contracts shortly. Every contract has to have at least two parties: an offerer, the party that makes the offer, and an offeree, the party that accepts the offer. Um, what happens is the offerer and the offeree, they have a meeting of the minds, mutual assent. They agree to be bound. They agree to be legally obligated to each other. Once you have that, you have a contract. Now, I'm going to go over the sources of contract law briefly. Why? Well, contract law can be strict or it can be extremely liberal, but it's important to know both, but all three sources. The first source I'm going to go over is really nothing more than an encyclopedia of law, kind of like a snapshot of what's happening in the law across the 50 states. And that's the Restatement of Contract Law. Every so many years, a group of attorneys and legal scholars get together and they draft the restatement. And there is a restatement of contract law. As a matter of fact, there's a restatement of tort law, there's a restatement of criminal law, there's a restatement of all areas of the law. So, and that's basically just an encyclopedia. It's like a good starting point. Gives you a sense of where the law is on any given subject. The next source of contract law is the common law. Now, we obviously covered this a couple of classes, maybe the first or second lecture. What the common law. Now, common law, that's judge-made law. Now, many of those principles have been encoded in statutes. But still, there are many areas of contract law that are controlled by the common law. And the thing about the common law is that when it came to contracts, it was really strict and really rigid. And we'll go over some ways how that was so. The third source of contract law, and this is really important, is statutory. Right? In the United States, we have two sources, controlling sources of law. We have the common law, the courts, and we have the legislatures. They pass statutes. Now, the most important statute as far as contract law is concerned is the Uniform Commercial Code, the UCC. About 50, 75 years ago, there was a recognition that the United States was becoming a national economy. And each state had its own commercial laws. And it worked okay, but it was starting to be seen as an impediment. And the thought was out there that, maybe if the states all had the same or at least similar commercial laws, this would be good for the economy. So starting after World War II, a group of scholars got together and they drafted the Uniform Commercial Code, and they put it out there. And it was adopted. It was adopted by one state after another. At this point, Almost every state has adopted the Uniform Commercial Code in full or in part, the only exception being Louisiana. Why? Because Louisiana is not based on the English common law system. It's based on the French civil law system. And the Uniform Commercial Code is definitely a lot more flexible than the common law. It's a lot more liberal, if you will. Now, the Uniform Commercial Code covers a whole host of commercial and economic activity. Article 2 covers sales contracts. Article 2A covers leases. Article 3 covers negotiable instruments, also known as promissory notes. Article 4, bank deposits. Article 4A, fund transfers between banks. Article 5, letters of credit. Article 6, bulk transfers. Article 7, wholesale receipts and bills of lading. Article 8, investment securities. And Article 9, secured transactions. So it's a really broad statute. It covers really almost all economic activity. And it's been adopted now by almost every state. And it's considered a success. It really has made a big difference in terms of doing business from one state to another. All right, I want to go over the different types of contracts. Very important. Now, the most common form of a contract is referred to as a bilateral contract. Now, a bilateral contract is where the offerer offers a promise and the offeree makes a promise in return. So it's a contract supported by two promises. No one has done anything yet. So the offeree, I promise to deliver, and the offerer, I promise to deliver, and the offeree, I promise to pay. Bilateral contract. It's a promise for a promise. And it is, in fact, legally enforceable. Now, so that's a bilateral contract. Now, what if you have a bilateral contract and it has yet to be performed? All that's out there right now are promises. That's referred to as an executory contract. An executory contract is basically a bilateral contract which neither party has performed. Neither party has followed. Neither party has honored their promise as of yet. But what if one party does and another party doesn't? Well, then that's referred to as a partially executed contract. That's where one party has fulfilled its promise, but the other hasn't. What if both parties do fulfill their promises? Then it's referred to as fully executed. So far we have bilateral contracts and executory contracts. Now, bilateral contracts, they have two promises exchanged. There are also unilateral contracts, and that's where the offerer makes a promise, but they're not seeking a promise in return. They're seeking performance. They want the offeree not to make a promise to perform. They want the offeree to promise. So, for instance, suppose I were to ask one of you, I will pay you $1,000 if you paint my garage. I'm not looking for a promise from you to paint my garage. I want you to paint my garage. Now, the thing about a unilateral contract, which is really important, it's not enforceable. With a bilateral contract, once the promises are exchanged, the contract is enforceable. With a unilateral contract, it's not enforceable until the moment that performance is 100% complete. What does that mean from a practical point of view? Well, suppose, for instance, you're painting away. You're painting my garage, and you're looking forward to getting paid $1,000. And you're 90% done. And I tell you, well, thank you very much. You're fired. Can you sue me in contract? No. There's no contract. You did not fully perform. Does that seem fair? No. But too bad, so sad, there's no contract. Obviously, that's not fair. So what the courts have done is they've come up with an equitable doctrine. Remember way back when we talked about equity? It's based on the idea of fairness, doing what's right, getting someone to do something. Well, they came up with this equitable doctrine called quantum meruit. Quantum meruit. What is that? It means you get the value of the work you've done, basically. And along those lines, they've come up with this theory, this legal theory of quasi-contract. Now, it's not really a contract, so I wouldn't list this as a new type of contract. This is kind of an outlier to unilateral contracts. And quasi-contracts are premised upon the idea of quantum meruit, that you should get the value of what you provided. So, for argument's sake, suppose you completed 90% of the work, and there's nothing wrong with the work. Then, what might the court rightfully decide? That you were entitled to what? Obviously, what? 90% of the pay. So, quantum meruit. Quasi-contracts, an important idea. It also applies, by the way, to sales contracts for goods. You know, a lot of times, sales contracts, it's not about one big delivery, it's deliveries over time. You know, maybe 4 or 5 deliveries, you know, over a couple of weeks or a couple of months. Well, in that situation, you know, suppose the party cancels with 1 order left. And they say, you know, too bad, so sad, you don't have a contract. Well, then obviously, quantum meruit quasi-contract then comes into play. Another type of contract, which is important to know, or in terms of terminology, are express contracts. Now, express contracts are just that. The terms are expressed in words, either verbal or written. And as we'll learn shortly, certain contracts have to be written. So express contracts. Well, those are express contracts, and the opposite of express contracts are implied in fact contracts. Now, implied in fact contracts, what the court will do is they'll look to the behavior of the parties. Usually, implied in fact contracts grow out of fully executed contracts where the parties have fully performed, but they continue acting as if there is a contract. So, for instance, an example of that, a lease. Now, a lease really is nothing more than a contract giving you possession of some real estate. Suppose you have a 12-month lease with your landlord. The 12 months are up. First day of the 13th month, just as you've done the other prior 12 months, you write a rent check and you deliver it to your landlord. Landlord takes it, deposits it. 14th month comes around. Once again, the first of the month, you write a rent check, your landlord takes it and deposits it. Well, the courts may look at that and they say, well, even though the contract has expired, the written contract has expired, the lease has expired, the parties are acting like what? They're acting as if there is a contract. So we're going to call it an implied in fact contract. Now here there are 3 elements which are important to know. 1, the plaintiff provided a property or service to the defendant. 2, the plaintiff expected to get paid. And 3, the defendant was given an opportunity to reject the property or the services. As long as those 3 elements are satisfied, it's an implied in fact contract. Now, another important contract that you should know are options contracts. And it's kind of similar to the options market, if you're taking a class in that. But an options contract is based on the idea that you want someone to hold open an opportunity for you. So suppose, for instance, you came to me and said, Professor Ertel, suppose I'm a retailer. I sell men's suits. And you came to me and said, Professor Ertel, I would like to sell you 200 units, 200 men's suits at $100 per unit. We negotiate a little bit, and at the end of negotiations, I say, I am intrigued, but I'm not quite sure. Can I have time to think about the offer? And you come back to me and say, you know what, Professor Ertel, I'll do you one better. I'll keep this offer open and exclusive to you if you pay me a sum of money. So an options contract is when the offeree pays the offerer some kind of compensation to keep the offer open and exclusive for an agreed upon period of time. Very common in contracts, especially in business. Contracts can be formal or informal. It doesn't necessarily mean complex and less complex. I mean, a formal contract, for instance, is a check. What do you need for a check? Formal just means that there are certain requirements that must be in the contract. With a check, what do you need? Well, obviously you need your signature, but you also need the routing number and the account number. You've got to have those. So contracts can be formal or informal. All right, so what are the elements of a contract? When do we have a contract? Well, here, I do believe in acronyms, in mnemonic devices, and as a way of helping you study. And I have a good one for contracts. TACO, T-A-C-O. Every contract has to be a TACO. It has to have 1, essential terms, 2, acceptance, 3, consideration, and finally 4, an offer. Now that's not necessarily in order, but we're going to go over each one. We're going to cover the O first, the O and the T actually. They kind of go together, offer and terms. Now, the offerer makes the offer. Now, the offer has to manifest a present intent to enter into a contract. And it has to contain definite and unambiguous essential terms. So it has to manifest a present intent. So suppose, for instance, I were to tell you, I'll sell you my house 10 years from now for $1 million. Well, is that the present intent to enter into a contract? No, it's off into the future somewhere. It doesn't count as an offer. It's got to be right here, right now, or really soon thereafter. It has to manifest a present intent to enter into an offer. The offer also has to be serious. Offers made out of anger or jokes, they're not serious. There has to be some objectivity so that a person looking from the outside in would say, that was just a joke. A reasonable person looking in would say, that was just a joke, or they were just angry. They weren't being serious. So there's got to be a seriousness element to it. Offers have to be serious. Offers made out of anger or jokes do not count. They have to contain essential material terms. Probably the most important essential material term is the name of the parties. Right? The parties have got to be there. That's got to be there. The parties have to be identified, in other words. The object or objects have to be identified. The assortment has to be identified. Things like color, size, shape, style, that all has to be identified. Timing has to be addressed. Both delivery dates, time to accept. You have a right as an offeree to either accept or reject the goods. Time to accept the goods. That's got to be in the offer. Pay. Time to pay. When is payment due? Is it due when the goods are delivered, or is it credit being extended, or what time? How much time does the offeree have to pay? And if they miss the payment time, then what? Is there a penalty? If so, what kind of penalty? This, for instance, is a big issue in vendors' compliance manuals. Delivery location, really important. That's going to be there. Where are the goods going to be delivered? Quantity, how much? 1 unit or 1,000 units. It's got to be addressed in there. Price, of course, price. How much is someone going to pay for the goods? Now, under the common law, you had to contain all the essential material terms you wanted in your offer, and ultimately, once it's accepted, in your contract. If you didn't, it was a problem. The UCC took something of a different tack, and they realized that business oftentimes is fast-paced, and it's oftentimes kind of informal. Parties don't always go back and forth with such formality. So what the UCC did is they came up with what is known as gap filler provisions. Gap filler provisions. What are some gap filler provisions? So, for instance, suppose the payment terms were not addressed. When payment was due, how it was due, was it going to be check, cash, credit card, was it going to be some kind of barter, whatever the case may be. Suppose payment terms were not addressed. Well, the UCC says no problem. If payment terms are not agreed upon, payment is due when the buyer receives the goods or documents of title. A lot of times goods aren't actually delivered. Instead, you get documents of title, papers that give you the right to possess something. So that's when payment is due. Further, in terms of payment terms, how? Whatever is reasonable under the circumstances, whatever is commercially accepted. Price term. You would think that is pretty fundamental, that if you don't agree upon the price, you wouldn't have a contract. But the UCC says no problem. If you don't agree upon the price term, it's the reasonable price at the time of delivery. This works well, I think, with things like commodities, where you have markets all around the world trading every kind of commodity available. So if you wanted to buy, for instance, cotton, raw cotton, I mean, cotton is sold all around the world in commodities markets. So that would work pretty well. I'm not so sure I would leave the price terms open for finished products, products with a lot of value-added input. After all, especially with clothing, the value of the clothing is not just the actual materials themselves and the cost of assembling it. It's everything else that goes with it. It's the branding. It's a lot of kind of intangible sort of value there. You know, you have trademarks, you have copyrights, you have art. There's a lot of intangibles there. So obviously, I would hope that you include the price terms. But under the UCC, that's not a problem. If the delivery terms are left open, no problem. If they don't agree as to time, place, or manner of delivery, it is the seller's place of business. And afterwards, the seller is obligated to make shipping arrangements in good faith. What about time? What about open time terms in terms of payment or delivery? It's whatever is, quote, reasonable under the circumstances. Now, what if, for instance, I was selling milk and delivery time was left open? Well, milk is what? Milk goes bad relatively quick. So that what's reasonable for milk might be a little bit different than what's reasonable, for instance, for nuts and bolts. Nuts and bolts, do they go bad? Not really. You know, they can last a really long time. They can last years. So in terms of time, it's whatever reasonable under the circumstances. I would say that clothing, fashion, being divided into 4 seasons, time is pretty important, especially delivery time. You know, you've got to get the clothes out on the floor in time for what? In time for the season. So, you know, maybe clothing doesn't go as bad as milk as quickly, but it certainly doesn't last as long as nuts and bolts. What about the assortment? What about size and shape and color? Well, if that's left open, the buyer can make a selection from the stock as long as they do so in good faith. So, for instance, in the example I gave before, I sell men's suits. Suppose, for instance, the men's suits that I sell are for big and tall men. Well, for me to make a selection in good faith, would I be selecting size 40 medium? No, no, that's a small size. For me, it would be the bigger sizes, you know, 48, 50, 52, you know, large, extra large, and the like. So assortment terms, that could be left open. All right. Another thing about offers is it's more than just an invitation to negotiate. So suppose, for instance, I were to call you up. You know, again, I have a store. I sell men's suits, and I'm just inquiring about prices. You know, what kind of price can you offer me on these suits? I saw them in your catalog. I'm interested in them. What kind of price can you offer me on the suits? That's not an offer. That's just an invitation to negotiate. That's just doing research. That's another thing that's important about offers. Now, what about advertisements? You know, think about a used car lot. You know, come to Al's Used Cars for the best deal in town. Well, what if you do go to Al's Used Car and you don't believe that you got the best deal in town? Can you sue? Well, what does best deal in town mean? Best according to what? Price, size, color, gas mileage? Best is what? Is that an opinion or a fact? That's really more of an opinion. That's referred to as sales puffing, as puffery, sales puffery, or puffing. But what if, for instance, though, there's an advertisement. Come down to our grand opening, PC Richards, our new store, this Saturday. The first 200 customers or more to spend $200 or more get a free DVD player. Well, is that puffing? Is that puffery, sales puffery? Or are they actually making you, are there some definite terms in there? There are definite terms in there, aren't there? Come down on a specific day, be one of the first 200 customers to spend $200 or more. Those are some specific terms. So what if you do that and they don't give you your DVD player? Can you sue them? I think you could. I think you would have a pretty good argument that, hey, you fulfilled, there was an offer made and you fulfilled the terms of the offer, and you want to be paid. You want that DVD player. By the way, what kind of contract is this? Is it a bilateral or unilateral contract? It's a unilateral contract. The business, PC Richards, they're making an offer, and they're seeking what? Performance in return. They want you to come down that specific day, be one of the first 200, and spend $200 or more. All right. Now, once offers are out there, can they be terminated? Do they last forever? Well, they don't last forever. At some point, they can be terminated. One, you could put it in the offer itself when it's going to terminate. This offer is only good for 1 week, or 10 days, or 24 hours, or whatever. You could do that. You could put that in the offer itself. But there are some other ways that an offer can be terminated. One, the offeror revokes the offer, saying that the offer explicitly expressing that the offer is no longer open and valid. Now, if you're going to do this, if you're the offerer, I suggest that if you do it verbally, that you follow up in writing. This way, there's no misunderstanding. Email, fax, even snail mail, whatever the case may be. What about if the offerer or the offeree rejects the offer? Well, that actually terminates the offer. But what if the offeree changes their mind, say a couple of minutes later, and said, no, I'll accept the offer? No, the offer has been terminated. Once the offer has been rejected by the offeree, it is terminated. Now, these are all common law rules, which are a little bit stricter. What if the offeree instead makes a counteroffer? Well, a counteroffer also terminates the original offer. So if the offeree comes back, if I were to come back to you and say, if you make that offer of 200 men's suits at $100 per unit, and I were to say $50 a unit, well, that would terminate your original offer. The destruction of the subject matter of the offer through no fault of either party. So going back to our example again, you offer me the 200 suits. Suppose the warehouse where you store those 200 suits burns down to the ground and everything inside is destroyed. Well, the offer is also terminated. Death or incompetency of either party. So if I were to die or become incompetent before accepting the offer, then it would be terminated as a matter of law. Why? Obviously, if you're deceased, you cannot accept the offer. And if you're incompetent, you cannot what? Remember, a contract is what? It's a voluntary agreement between two or more competent parties. If you're incompetent, you cannot understand the legal obligations imposed by your action. Supervening illegality. The offer, something about the offer is now illegal. So, for instance, credit card offers, right? Every state sets its own limits in terms of interest rates. So suppose you get an offer from a credit card company, 15% interest rate. But the state that you live in, after the offer is made, they lower the highest rate that can be charged to 13%. What about that original offer of 15%? Is it still valid? No, it's now illegal. Because it's now illegal, the offer is terminated. Lapse of time, lapse of a reasonable time. What's reasonable? I think a lot of it depends upon what's being sold. If it's milk, maybe a couple of days. If it's nuts and bolts, maybe probably a lot longer. Maybe what you want to do in the offer is put that time is of the essence. That you have to make a quicker decision rather than a later decision. So offers, they can be terminated. So the offers, again, they contain the essential material terms that you want included in the contract. So we covered the O and the T. What about the A, acceptance? Well, acceptance is when, under the common law, acceptance is where the offeree agrees to all the terms and conditions in the offer. To be valid, it has to be made, the acceptance has to be made by the party to whom the offer was extended. So if you made me that offer to buy 200 suits, $100 per unit, I could not turn around to a friend of mine and transfer that offer. I could not assign it. Hey, look, I got a great deal here. I don't want to take it, but you can take it. I have a great offer here. I can't take it, but you should take it. No, can't do it. So the acceptance has to be made by the party to whom the offer was made. Two, it has to be unequivocal. The acceptance has to be unequivocal, meaning that the offeree accepts all the terms and conditions. Now, again, that was under the common law. Three, it must be made by a reasonable mode or that called for in the offer. You could put in the offer that the acceptance has to be made, within 24 hours by telephone call, or the acceptance has to be made by telephone call or fax or email or whatever the case it may be. If it's not addressed in the offer, then whatever is reasonable under the circumstances. Now, under the common law is very strict. The common law required that the acceptance had to be made in the same mode as the offer. So if the offer were sent by first-class mail, the acceptance had to be sent by first-class mail. What if it was sent by FedEx? Even though that's arguably better than first-class mail, gets there sooner? No, not at all. It's actually, even though you may assent to all the terms of the offer, it may be unequivocal, your acceptance, that's considered a counteroffer. So it has to be made by any reasonable mode. The acceptance has to be either an act or a promise. If it's an act, what kind of contract is it? Unilateral contract. If it's a promise, it's a bilateral contract. Okay. If it's a unilateral contract for the sale of goods, so in other words, the offeror has made a promise for goods, but they want the offeree to just deliver the goods. If the offeror wants to, if the offeree wants to accept under the UCC, the offeree has to tell the offeror ahead of time that they are in fact delivering the goods. The offeree has to know that the offer existed before he began performance, whether it's performance itself or a promise. Here's one that's important. The acceptance must be affirmative. What does that mean? That means it's got to be something done. So for instance, I get a bill from some children's magazine, and it's for a lot of money. And I said, that's odd. I didn't order this magazine for either of my children. And I asked them, and they said, no, they didn't order it. And then I call up the magazine, and I said, well, there must be some mistake. I received this bill, but I did not order this magazine. neither did my children. They tell me, no, 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 you accepted. We sent you an offer. And in that offer, we said if we do not hear from you within 30 days, we will deem that an acceptance. Can my silence be an acceptance? Absolutely not. Absolutely not. It's so. In other words, you have to do something. You have to say something. You have to write something. You have to act in a specific way. Silence cannot be acceptance. What if there were identical cross offers, right? At the time that you made me the offer of 200 suits, $100 per unit, I also made you an offer to buy 200 suits at $100 per unit. Well, under the common law, that was not a contract. Why? Because to have a valid contract, you have to have TACO. You can't have a TUCO, TOCO. No, you have to have a TACO. You have to have terms, acceptance, consideration, and offer. You can't have terms, counteroffer, consideration, and offer. That's a TUCO. That's not a contract. But the UCC, under the UCC, they take a different approach. What does the UCC say? Yeah, sure, absolutely, that's a contract, without a doubt. So that's just some things to know. All right, I'm going to save the rest of the material for another lecture. So keep up to date and email me any questions. Thank you.